Friends, in session number 21 relating to military laws series, we would see what are the provisions pertaining to summary punishments. Now, summary punishments, as the name indicates, are summary. The delay is cut short and they are meant for instantaneous infliction of punishment where an offender is guilty, and that way to aim to maintain discipline. The suitable provisions for this are to be found in section 80 to 82 of the Army Act and Amir Rule 22 clause 3 contains the procedure for conducting summary punishments. Now here there are two words used, two terms used, and there are two processes. One is called summary court martial, other is summary trial. Now what's the difference between the two? In any case, a summary process is simplified and abridged judicial process. Summary court martial can be held by the commanding officer of any corps, department, or regiment of the regular army. It has to be conducted by the CO or commanding officer of the accused, and he alone constitutes the court. On the other hand, a summary trial is a form of trial which is well established as per the customs of the service, and in this the formal legal procedure is quite cut short, and it means immediate and instantaneous disposal of a matter. At that time, it is quite likely that an offender would be in military custody, which means that he would be arrested or confined according to the usages of the service, and military custody term includes naval or air force custody. Insofar as detention is concerned, which is one of the punishments that can be awarded under section 80. Now, during detention, a defaulter is subjected to same restrictions as the one who's undergoing rigorous imprisonment. In the records of the offender, it comes as a red ink entry, but he does not forfeit pay and allowances for the period of detention, which would be the case when a person has been sentenced to imprisonment. Various punishments that can be given as part of summary disposal or a summary punishment, summary trial, are alpha, imprisonment in military custody up to a period of 28 days, or detention up to 28 days, confinement to the lines up to 28 days, then fourth, extra guard or duties, then deprivation of acting rank. If someone is holding an acting rank as opposed to substantive rank, then he can be reduced to a lower grade of pay, or he can be made to do away with acting rank. For example, if it was an acting nayak, then he would just become a soldier or a rifleman. Forfeiture of good service and good conduct pay. The NCOs can be awarded severe reprimand or reprimand. There are also provisions for fine up to 14 days in 1 month, and apart from that, penal deductions. One of the punishments was confinement to lines. Now, this is an addition, or this is distinct from rigorous or simple imprisonment or detention. Confinement to lines, as the name or the term indicates, the person is expected to remain within the lines where the residential area of the troops, and at unspecified times he is told to report to his superior. For example, his superior may say that you will report to me at an interval of every 3 hours or every 2 hours, and he can be employed for the normal errands, that is the working parties, to the fullest practicable extent, and other than that he is supposed to attend all parades and duties which are performed by the regular soldiers. A word about what can be the punishments that can be combined and what is their limit. Now this is there in section 80, and it says that as far as imprisonment in military custody, detention up to 28 days, confinement and extra guard, all these will be not more than put together 42 days. And if these are awarded, then the punishment of confinement and extra guard will take place only when the imprisonment and detention has been done. So the point is that not more than 42 days, and if imprisonment or detention is there, then they would be made use of first, they would be inflicted first, followed by confinement or extra guard. And insofar as punishment of reprimand or severe reprimand is concerned, this is not to be given to a person below an NCO rank. That means, for example, a gunner or a sepoy cannot be awarded severe reprimand or reprimand which is only meant for the NCOs. Then Army Act Section 82 states that Chief of Army Staff may specify, with the consent of the central government, certain other punishments in addition to those that are reflected in Section 80. What does it mean? It implies that other than what is indicated in Section 71 and 80, the commanding officer can, with the permission of the central government, to specify the Chief of Army Staff may do so that the commanding officer can give following punishments. So the authority is with the Chief of Army Staff, and the limitation is that he has to first obtain the consent of the central government, and then it would be applicable across the length and width of the army. Now, there is a document or a form called offense report, and this offense report is a document which is available, can be seen under the Army rules on page 202. I will shortly show it to you, where a record of the proceedings conducted under summary punishment is to be recorded. Before I go to the form, a point about Amir Rule 22. This is mandatory in the case of Section 80 also. So therefore, you would recall I had said that this is the first opportunity where an accused can disprove the charge against him, can rebut, can give his version. So compliance of this Amir Rule 22 is mandatory even in the case of Section 80 that pertains to summary punishment. And this was so held by the Supreme Court in PPS Bedi's case, and for that the procedure is to comply with the offense report form, where proceedings under Section 80 are also made use of. Now this in front of you is the form for use at summary trial for NCOs, which I called the offense report. On the left hand you will find that offense report. In front of it is the name of the battery, squadron or company will be kept. For example, Alpha Company 4 Rajput, or Papa Battery of 213 Medium Regiment, like that. Then there is a place for charge against number and rank. So offense report is distinct and separate for each person. It is written on top, serial number. So if there are more than one offense report, proper record is kept for which week. Last report is to be linked. Name of the individual is to be mentioned. And then there are the columns you find, these vertical columns, place and date of offense. What is the offense, whether it is theft or it is absent without leave. The plea advanced by the accused, whether guilty, not guilty, who were the witnesses examined, and then column 5 says what punishment was given to him, and then the commanding officer will put his signature in column 6 with the rank designation, and then it would be the day the entry is put in the conduct sheet is to be written there, and it is signed by the signature by the officer commanding of the unit. So this is the offense report which is to be used by the commanding officer when he is dealing with the case by way of summary punishment. Now, therefore, it is to be borne in mind that compliance of Amir Rule 22 is to be done in the first stage, followed by the offense report procedure. And offense report is also to be used if a punishment is be given under section 82, which I had said that commanding officer can give those punishments if the chief of army staff has so specified with the consent of the central government. And then there is a need for Army Rule 192 to be borne in mind, which lists out what is the extent of punishment. And 192 says that if the commanding officer is of the field rank, and field rank is majors and above, then he can exercise full powers which are there under section 80. However, if the commanding officer is below uh, field rank, that means he is captain or lieutenant, then he can award imprisonment and detention only up to 7 days and remainder punishment to the full extent. So therefore, by implication, as against 42 days which was there if the commanding officer is of a field rank, on the other hand, if he is below field rank, that means captain or lieutenant, then he can only give up to 7 days punishment. So this is because of the experience and the authority, the limit has been so laid. A recommendation here, you may perhaps agree with me that action should be taken and steps should be instituted so that this procedure is more fair and transparent. This is not to be taken to mean that presently it is not fair and transparent. However, there is always a scope for extra steps instituted in that regard. Some other specific suggestions that I would like to say that prior compliance of Army Rule 22 be made mandatory. So far, it is only because of the decision of the Supreme Court in PPS Bedi. However, if compliance is inserted in the Army Act or the rules, then it would have greater potency and authority. Secondly, the procedure of summary disposal should be attended by 2 independent witnesses and their signatures obtained. Now, that would authenticate the process that has been set in motion by the commanding officer. Next, that let the signatures of the accused be also obtained and put on the offense report, and a copy of the offense report should be provided to the accused. After all, there is no reason why, if he has been proceeded against, he should not have access to a copy of the proceedings. So far, it's not there, but these suggestions are nevertheless, they do merit consideration. Finally, I would like to say that it is for the commanding officers to ensure and bear in mind that summary punishment should not only be fair and legal, prompt and legal, but it should be fair also, and so that the authority, the action taken inspires confidence. Thank you.